The attorney for responding mother, Ms. Palmer.
Justin Dale for the AG's office.
Okay, with those who intend to testify, please raise your right hands. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. You may lower your hands. This motion for enforcement was brought by the state against respondent father alleging failure to pay child support and medical support. Is that correct?
That is correct, Judge.
All right, and prior to going on the record, there was some stipulations made to exhibits. So state's exhibit A is admitted. Respondent mother's exhibits 1 is admitted as a summary, and then exhibits 2 through 4 are admitted, and respondent father's exhibit 1 is admitted. Is there anything else we're missing for the record in regards to the exhibits?
Not at this time, Judge.
Not at this time, Judge. Okay. All right, are there any preliminary matters that the court needs to take up?
Not at this time, Judge.
No, Judge. Okay. Attorney Dale?
Let me ask the state judge, can I proceed?
Yes, so you all are set at, this is a 30-minute hearing, so you have 10 minutes aside. They'll include any opening statements and closing statements should you all choose to make them, as well as any examination. All of your exhibits are admitted, so you don't have to lay any foundation or anything on those. You can just jump right into your examination. State, would you like to make an opening statement? Okay, Attorney Mitchell?
I'll waive opening, Judge.
All right, Attorney Kamuche?
I waive, Judge.
Okay, State, you may call your first witness.
State will call mother judge.
Okay. Joey, do you need Attorney Dale to come to a microphone? Okay. All right. Just make sure you put a microphone close to your mouth. Okay. And counsel, whenever you're ready to proceed.
Judge, I would first ask the court to take judicial notice the underlying order in this action entitled Order of Suit Affecting the Parent-Child Relationship, signed by the court on April 19th, 2024.
Okay, the court takes judicial notice of the order as well as all contents of the court's file.
Thank you, Judge. And just for clarity purposes, states A has been admitted into evidence a current terror case. Is that correct?
Yes,
Okay, thank you, Judge.
you're welcome.
And Ms. Palmer, what is your full name?
Renalda Palmer.
Here's Ms. Palmer, you and Mr. Hammonds have how many children together?
1.
What is that child's name and age?
Hayden, age 5.
And you understand we are here today to enforce the order signed by the court on April 19th, 2024.
Yes.
Okay, and in that order was who's the child's father?
Mr. Hammonds.
Okay, and received order to pay child support in that order?
Yes.
How much he was ordered to pay?
It was broken down. So I think the financial was about $1,200, and then there was medical that was broken down according to the contributions. I think that was like an additional $250, $270, somewhere in there. I don't have the exact numbers.
Mr. Hammond was ordered to pay $1,220 a month in child support.
Yes,
He was also ordered to pay medical support in the amount of $142.52.
yes,
And he was also ordered to pay a dental support obligation. Is that correct?
yes,
Was that amount $30.75?
yes.
Okay. And it's your knowledge, is Mr. Hammond's current on his child support, medical support, dental support payments?
No,
Okay, before we get to the contempt portion, you're requesting that the judge confirm judgment today in child support, is that correct?
yes,
Okay, so I understand that the state is requesting that there be a child support judgment against Mr. Hammond in the amount of $19,555.23.
yes,
Okay, and you understand that's as of November 30th?
yes,
And you're asking if you were to pay that at, or rather, would you agree that if you were to pay that at $200 monthly?
do I agree with that?
Yes. Like that, Judge, I'll rephrase.
No,
Ms. Palmer, you're asking the court to issue a reasonable payout for Mr. Hammond to pay that money back. Is that correct?
yes,
Okay, you also are asking that there be a medical support judgment of, as of November 30th of $4,077.93.
yes,
You're asking the court issue a reasonable payout for that, correct?
yes,
And lastly, the dental support, you're asking that there be a judgment against Mr. Hammond in the amount of $893.15. Is that correct?
yes,
Lastly, you're asking that the court issue a reasonable payout on that amount.
yes.
Okay. Okay, and Ms. Palmer, do you recall if Mr. Davis made a payment of his child support and medical support and support payments on April 2024?
I do recall, but there was no payment.
May of 2024.
Not that I recall.
Judge, may I have a 5-minute recess?
Hold on one second. What was your question?
May I have a 5-minute recess?
Yes. Yes. All right, the court is in recess 5 minutes. All right. All right. All rise. Y'all may be seated. Okay. We are back on the record. State you have 3 minutes and 40 seconds left.
Thank you, Judge.
Go ahead.
Ms. Palmer, I want to make it clear to you, we're here today because we felt it accurate because Mr. Hammond was not paying his job support. Is that correct?
That's correct.
Yeah, we're getting some dates straight. And so, to your knowledge, Mr. Hammond paid a full child support, medical support, dental support payment in the month of May of 2024.
Not that I can recall.
In October of 2024. Okay.
So there was a large payment, like a garnishment in that time frame. So I don't know if that payment was made by him or if it was,
To your knowledge,
yes. Well, not in October. No. No.
December,
No.
your knowledge, 4 months that Mr. Hammond's not paid for full payments. Is that correct?
That's correct.
Okay. And is Mr. Hammond's here with us today in the courtroom?
Yes.
Okay, where is he sitting?
At the end of the table nearest you.
You know, Jack,
Black.
on the kind of nearby, Mr. Hammond's father, the courtroom is with the black jacket.
So noted.
Thank you, Judge. And Ms. Palmer, you're asking if Mr. Hammond be found to be in contempt for his non-payment. Is that correct?
Yes.
Okay, you're asking that he be found in contempt and that he served at least 180 days in the Dallas County Jail. Is that correct?
Yes.
And you're asking that his sentence to run concurrently on those violations. Is that correct?
Yes.
Okay. And to your knowledge, Ms. Palmer, is there any, to your knowledge, was Mr. Hammond's employed the last year?
I'm not sure, honestly.
We'll ask the witness to reserve some time for closing.
Okay.
I have no questions of this witness.
Okay.
Ms. Palmer, were you present at the trial that took place in April of 2024?
Yes.
And was Mr. Hammonds present at the trial that took place in 2024?
Yes.
And is that the same Mr. Hammonds that you've identified in this courtroom?
Yes.
And at the time of that trial, did this judge read her ruling out to the court?
Yes.
And did that include the amounts that he was ordered to pay?
Yes.
Subsequently to that trial date, were you present at a hearing on the motion to enter that final divorce decree?
Yes.
And was Mr. Hammonds also present?
Yes.
And so he was present when the order was signed related to how much he was ordered to pay. Is that correct?
Yes.
When this action was filed for the motion for enforcement, it was filed by the state. Is that correct?
Yes.
And at the time that it was filed and you were served, were you represented by an attorney?
No.
And at some point when you appeared in court, is it true that you would have appeared in front of the associate judge related to child support?
Yes.
And at some point, did Mr. Hammonds hire counsel?
Yes.
And did he ask that it be removed to district court?
Yes.
And have there been at least two hearings subsequent to you appearing the first time for that motion for enforcement? Two hearings after the first time you appeared?
Yes.
And was that part of the reason why you decided to hire counsel?
Yes.
Did you agree to pay my office $400 per hour for my time?
Yes.
Did you agree to pay my office $150 per hour for the time related to my paralegal?
Yes.
And did you agree to pay $105 per hour for the time for my staff?
Yes.
And do you believe that the service that you've received has been reasonable and customary?
Yes.
At this time, are you asking that this court order Mr. Hammonds also to pay your attorney's fees?
Yes.
And that is the attorney fee statement that we provided with this court. Is that correct?
Yes.
So you're asking that he be ordered to pay $3,080 to you directly for your attorney's fees?
Yes.
And in addition to that, when we're talking about the amount that he's ordered to confirm, now you're asking this court to confirm the judgment that he owed based on his pay record. Is that correct?
Yes.
And so based on the pay record as of November 30th, 2025, he would have owed $20,775.23 in child support, correct?
Yes.
And is that the judgment you want in your favor?
Yes.
Related to medical support, are you wanting the judgment of $4,220.45 in your favor against Mr. Hammonds?
Yes.
And as it relates to dental support, you're wanting $923.90 in your favor, a judgment against Mr. Hammonds.
Yes.
Now, to be clear, is the child receiving private health and dental insurance?
Yes.
So all of those fees would be owed to you and not the state.
Correct.
So that full judgment should be just in your name.
Yes.
Right. And so in addition to asking for those judgments as well as your attorney's fees, you asking for this court to find him in contempt of court
Yes.
for both child support, medical support, and dental support.
Yes.
And all those desires are reflected on the summary of your requested relief.
Yes.
My final questions to you is if this court were to order that he were to pay on those judgments, are you asking that whatever the court orders that he pay on those judgments be in addition to what he's already court ordered to pay?
Yes.
And would it also be true that after this motion was filed, he continued to not pay child support in full each month?
Yes.
So this motion was filed sometime in March of 2025.
Yes.
And every month since then, he's either failed to pay or failed to pay the full amount.
Yes.
Do you have reason to believe that he will continue to violate this order?
Yes.
Are you asking the court to consider that as it relates to its punitive nature?
Yes.
Pass this witness.
Okay, anything further for this witness?
Nothing further to say.
Okay, ma'am, you may return to your seat. State may call his next witness.
If I have no more witnesses.
Stay rest. Okay, Attorney Mitchell.
Call Mr. Hammonds.
Okay, Mr. Hammonds, you may have a seat there. Just pull the microphone close to your mouth. No, here. Yes, sir. And whenever you're ready, counsel.
Tell the court your full name.
Marquise Hammonds
Now, Mr. Hammonds, where are you currently working?
at Ivan Agency. Ivan Hudson Agency.
Is that a yes?
Say it again?
Did you say yes or mm-hmm?
Yes.
Okay. And how long have you worked at this agency?
Approximately 2 weeks now, 3 weeks.
Okay. And how much do you earn at this agency?
$11 an hour.
Prior to you beginning your employment at Ivan Agency, where were you working?
Unemployed
How long have you been unemployed?
since June of 2023. I was laid off
Okay. And in June of 2023, where were you working?
at Da Vinci Micro Fulfillment.
Okay. And how long had you been at Da Vinci Micro Fulfillment?
Almost a year.
What were you earning at Da Vinci Micro Fulfillment when you were laid off?
About 100,000.
And was that the amount that your child support was based on?
Yes,
Now, you've been unemployed since June of 2023, correct?
correct.
And you've not made any child support payments towards the child support that you were ordered to pay?
I have.
Okay. When was the last time you made a child support payment in the amount that you were ordered to pay?
And the amount that I was supposed to pay back when I was working.
Have you sought employment since you were laid off in 2023?
Yes.
What has been the issue with you obtaining gainful employment?
Well, currently it's because I have a pending felony case.
Okay. And when did you get this felony case?
That was last year, July 31st.
of 2024?
Yes,
And has that stopped you from obtaining gainful employment?
yes,
Have you received unemployment since you were laid off in June of 2023?
yes, I did approximately 6 months.
And from your unemployment, were your child support payments being made?
They was taking half of it, so $1,000 was being paid towards my child support.
Now, you are aware that you are currently in arrears in child support as of November 30th in the amount of $19,553.23, correct?
Correct,
And you've not made any payments for the month of December, correct?
correct.
Have you had the means to make any payments towards your child support since you've been terminated?
No,
Okay. And you're aware that you're currently in arrears for your medical support in the amount of as of November 30th, 2025, in the amount of $4,077.93, correct?
correct,
And you're also aware that you're in arrears on your dental support as of November 30th in the amount of $893.15, correct?
correct,
You have not made any payments for the month of December, is that correct?
correct.
Do you have the means to make any payments towards your child support at this time?
No, just what they gonna start taking out of my check.
Okay. You understand that you are in contempt of court for failure to follow the court's order, correct?
Correct.
Are you asking the court to just hold you in contempt at this point?
No,
Okay. Are you asking the court to defer any type of jail time at this time?
yes, I don't want to go to jail.
Are you asking the court to give you a suspended commitment?
On my payments? Yes,
No, a suspended commitment so that you aren't ordered to go to the Dallas County Jail.
yes,
Okay. And if the court places you on these suspended commitments, would you make every effort to pay your child support payments each month?
yes.
I'll pass this witness.
All right.
You can just, were you present at the trial in April of 2024?
Yes,
And isn't it true at the time of April of 2024, this court ordered you to pay child support, cash medical support, and cash dental support?
yes,
And you just testified that you were laid off in 2023, is that correct?
correct.
And did you provide information to this court at the time related to that?
That I was laid off?
Correct.
Yes,
And this court continued, based in its discretion, to continue to order you to pay child support, is that correct?
yes,
Okay. Now, you were also present at the entry hearing when that order went in place, correct?
in April?
Yes, in April.
Yes,
So you were well aware that you were ordered to pay and there was a signed order from this court related to your payments.
yes,
Okay. Now, you indicated that you were laid off in June of 2023, but you obtained some employment. When was the first time you obtained employment after that?
after June of 2023?
Correct.
That'll be, what, 3 weeks ago?
So you have not worked since June of 2023 until 3 weeks ago?
Yes.
Okay. And how much have you paid your attorney?
My girlfriend paid 900.
So you've only paid your attorney a total of $900 today?
Yes,
All right. And so in your answer, you indicated that you didn't have any resources or you couldn't borrow the money. Is that what you put in your answer?
that I couldn't borrow the money?
You couldn't borrow the money to pay your child support?
The full amount? Oh,
Any amount?
I've been borrowing, that's what I've been paying, so $200-300 a month.
Okay. Did you ask your girlfriend to let you borrow the $900 to pay on your child support?
Yes, and she said it should go towards a attorney.
But when she gave you the money, what decision did you make? To pay your child support or to hire an attorney?
I needed an attorney to get it modified.
And did you contact the Office of Attorney General to get a modification?
Yes.
And were you successful with that?
No, my baby mother, Ronaldo, didn't show up.
And wouldn't it be true that at some point you were found to have been intentionally underemployed?
No,
What are your felony charges?
just possession of marijuana.
How did you purchase marijuana?
I didn't purchase it.
Okay. Where did you get it from?
Objection.
I'm not saying that.
What we're talking
Hold on
about?
1 second. The question was, what are your felony charges? It is possession of marijuana. How did you purchase, which one did you object to?
Where he got it from?
Where did you get it from? Okay, what's the relevance on that?
Judge, he's indicating that he doesn't have resources to be able to pay for his child support. Surely if one is sharing contraband, they would be able to also share resources to pay child support. Just wanted to point that out to the court.
And Judge, that's still not relevant to this particular cause of action.
Sustain.
Now, you said your underlying charge is possession of marijuana. You understand that in order for it to be a felony charge, it would have had to be over 2 ounces. Do you understand that?
Yes.
Do you know how much 2 ounces of marijuana is worth?
Objection relevance.
That he doesn't have resources.
Overrule.
Do you know how much 2 ounces of marijuana is worth?
I do not.
Pass this witness.
State.
Question.
Okay, redirect.
I have no further questions to this witness, Judge.
Okay, sir, you may return to your seat. Attorney Mitchell, you may call your next witness.
I have no further witnesses, Judge. I rest.
Okay. Attorney Kamuche?
I would call myself as a witness, Judge.
Okay, go ahead.
Do you want me to come to the witness stand or can I stand?
No, you can stand right there.
Thank you, Judge. My name is Tiffany Kamusha. I've been licensed to practice law in the state of Texas since 2011. I have primarily practiced family law since 2013. My current billable hour is $400 an hour, with my staff's billable hour at $105 and my paralegal at $150. I believe those fees are reasonable and customary as it relates to this case. As of filing this case today, my client is asking for attorney's fees in the amount of $3,080. That included my appearance at the hearings in this case, reviewing the pleadings, as well as preparing for this hearing today. And so I believe that my fees are both reasonable and customary. I provided an itemized invoice to both the court and counsel, and I passed myself as a witness.
Thank you, counsel. Any questions for this witness?
No questions, Judge.
Okay, I have a question. How much was the filing fee?
For her answer, Judge,
Yes.
she just filed an answer. We just filed an answer.
Oh, yeah, that's right, the state.
Yes, Judge.
Okay, what about any other costs?
No, Judge, we didn't have any other costs.
Okay, so the amount is just $3,080 for the attorney's fees?
Correct, Judge.
Okay, got it. All right, thank you, counsel. Attorney Dale, closing?
Thank you, Judge. The state is asking that the court find that Mr. Mark B. Sammons have made his timely child support, medical support, real support payments for the affirmation dates, and that he be found guilty for each act of contempt, and that for the specified failure to do so. We're asking that he be found in consent to the instance to no more than 180 days in Ellis County Jail. We're asking that he defer, Judge, and that the court set a reasonable report back time, preferably after, I believe, the January 15th, 6 potentially.
Okay. Attorney Mitchell?
Judge, I waive closing.
Okay, Attorney Kamuche?
Hey, Judge, we'd simply ask that the respondent be held in contempt of court, and then the request of relief we've asked on our summary of request of relief be granted. And that if the court were to order, as relates to the judgments, we're asking that the court order the judgments based on the pay record, and that the payments on those judgments be above what the amount of the interest rate would be. So, Judge.
All right, what would be could you tell me the payout amounts again? I know the state asked for 200 on their 19,555.23. What were your payout amounts again?
We didn't have any specific payout amounts. We just had the judgment amounts based on the pay record. I think
Okay.
the state's amount might include payments that might have come in after we submitted the individual pay record.
Okay, so that's what your, I have your payout for child support. What are your payouts for medical and dental?
Medical, Judge, is 80, dental is
And would that be above the amount that, mother is asking for?
child support, yes, Your Honor. Yes, yes.
Okay. All right. The court, after considering the testimony and the evidence submitted, the court is going to find that Mr. Hammonds is in contempt for violating the court order. The court is going to affirm the arrears as of November 30th, 2025 for child support in the amount of $20,775.23. That's to be paid at $200 per month. Medical support judgment of $4,220.45. to be paid at, that's as of November 30th, 2025, to be paid at $80 per month. Dental support, $923.90 as of November 30th, 2025, at $25 a month. The dates related to the contempt are March 3rd, March 2024, October 2024, November 2024, and December 2024. The court grants the request for the amount of attorney's fees of $3,080. That's the judgment amount. Mr. Hammond, you're ordered to pay that amount. You can either pay it out in installments or you can pay it in full. It needs to be done. I can give you 6 months to get that taken care of. I can give you until June the 30th of 2026 to take care of those arrearages. The court is going to order that Mr. Hammons is placed in Dallas County Jail for a period of 180 days. However, the court is going to suspend that commitment and give you an opportunity, Mr. Hammond, to pay down some of these arrearages and get in compliance with the court order, okay? I'm going to place you on probation for a period of 12 months, and we will have a report back date in February of 2026. Does everyone have their calendars?
Yes, Judge.
And we'll get the probation office down here so you can go ahead and get everything set up with them today. In February, I have February 9th, 16th, and the 23rd, all open, first sittings at 9 a.m.
9th to the 23rd.
The 23rd works for me.
Will it be in person or on Zoom, Judge?
Preferably in person.
The 23rd.
Okay. So let me go ahead and add that on the calendar.
And Judge, since it's a report back, do you need Ms. Palmer to be present?
She does not have to be present. You have the option to, though, if you like to. I didn't want to make it seem like you couldn't come. And I'm indicating that that is an in-person hearing. Mr. Hammonds, I'm ordering you to appear here in person on Monday, February 23rd, 2026 at 9:00 a.m. The same courtroom you're in, located at the George Allen Courts Building, 255th District Court on the 4th floor, the new wing at 600 Commerce Street, Dallas, Texas, 75202. Your failure to appear may result in a capias warrant being issued for your arrest. Do you understand those instructions?
Yes, ma'am.
Do you have any questions about those instructions? No? Okay. Did I miss anything?
Judge, I just want to clarify the arrearage amount. For child support, on November 30th, the arrearage amount was $19,555.23.
That's right. I read yours. I'm sorry. My apologies. Child support amount is $19,555.23 as of November 30th. Medical support is $4,077.93 as of November 30th. Dental support is $893.15 as of November 30th.
Thank you, Judge.
You're welcome. Anything further for the record?
Judge, just to clarify, the probation period is 12 months?
Yes. Was the state looking for something else?
No, Judge, we were asking deferred, but if it's suspended, the state would ask for 5 years, Judge, to get this paid down.
Okay, is there any objection to the 5 years?
Yes, Judge.
We don't ask
That's,
that.
that's a long
It's a
time.
long time. I would rather 12 months.
Yeah, that's a long time. And, yeah, that's a long time for this amount. If the amount were a lot higher, I could see it. But for 19,000, 5 years is a long time.
And that stays request.
Okay, yeah, I'm going to deny that one. All right. Anything further?
No, Judge.
Okay, thank you all. Who's preparing the order?
Okay.
Okay. All right, you all are dismissed.
Thank you,
Thank you,
Judge.
Judge.
You're welcome. All right, and I think everybody is here for the next one. Arnell, you go ahead. Yes, please. Thank you. You all's food is here. Yes. So we have another hearing. I'm getting ready to admit them. Thank you, Attorney Dale.
Thank you, Judge. Thank you for your patience.
Of course. Good to see you. Good morning.
Good morning, George.
How are you?
I'm fine.
Good.
Good morning.
Who are we missing?
Okay. My client is on here. He's joining me here from the office.
Okay. Who represents? Who you? Oh. There you go. Counsel, who do you represent?
I represent the petitioner, Ayodeji Malcolm.
Okay. Let's see. Okay, I see your client. Ma'am, are you represented by an attorney? You're on mute.
No, I'm not.
Okay. Counsel, will you be proceeding on your client's motion that was filed on September 19th of 2025?
Yes, Your Honor.
Okay. Okay, what are the dates?
Say that again, George.
It's for a failure to pay child support, correct?
No. Well, apparently you are looking at the wrong one. My filing was on September 10, 2025. This is enforcement for property division by contempt.
Okay, I was looking at the other one. Okay, I see it now.
Your Honor, I filed the failure to pay child support.
Okay, did you get Mr. Malcolm served?
Yes, he was served on the 16th.
I do believe that Attorney General is not here. I don't know if they are, and they should be notified. I don't think that she did that. This hearing is strictly for my own petition.
Yeah, I don't see where you served the Attorney General, and I don't see where you set it for a hearing today.
I turned everything. I'm not a lawyer, but I turned everything in, and when I asked them at the court, they said all the hearing would be together. Like you would hear everything. I don't have to set a separate date since it's all related to the same case.
Okay. I don't know who gave you that information, but it's wrong information because of the nature of a motion for enforcement, the criminal aspect of it. Not only does he have to be personally served, but he also is entitled to notice of a hearing.
He was served. The sheriff served him. I served him through the sheriff. I paid to get him served.
Yes, you served him with a copy of the petition. You also have to serve him with a notice of the hearing. So he would have had to be notified of today's hearing for your motion. He notified you about today's motion regarding the petition for enforcement regarding the property, but you didn't serve him notice with your child support motion for today. So the motion is still on file. You just have to set it for a hearing. Unfortunately, because we're already here today, by law, I can't hear it. You have to set it and I have to hear it on a different day.
Okay, the last judge, because we met a judge before you, she also said the same thing that you would hear it all at the same time, and they never served me a notice for this hearing. She swore us in and said this hearing, so I assumed it was for everything.
No, that was bad information too, unfortunately.
Okay, I'll set it. I'll come back to the court and see how I can set it for a hearing.
Okay. Hold on. I believe that, if I'm not mistaken, I believe I recused myself on this case. I believe I did back in 2003.
Your Honor, I was not aware you recused yourself from this case, and I wasn't representing him at that time.
Yes,
So,
I did a voluntary on January 4th of 2023.
oh,
So why the administrative judge didn't reassign you all to a new court, I have no idea, because you filed a lot in this case in the past 2 years, and it's not supposed to be with me. So I can't hear anything. What I'm going to do is send this order, because I signed the order on, let me go back to it. It's on the court's record, the court's file too. I signed the order on January 4th of 2023. Let me see if I can share my screen so y'all can see it. Can you see my screen?
Yes, Your Honor, I can
yes,
see.
Yeah, I recused myself 2 years ago.
oh,
So what's going to happen is we can't have a hearing today. This case has to go to another judge. So I'm sending an email to the administrative judge so he can get that taken care of.
Okay,
And
Your Honor, go ahead.
go ahead. Go ahead.
Yeah, I do want to remind the court I have a vacation notice on file. I hope that will be taken care of as well, just in case it's set when I'm not available.
All right, so I'm sending an email now, so I'm releasing you all. So when the administrative judge reassigns you, it'll go to a different court. I don't know how that oversight happened, because they were still setting cases in this court. Okay, well, you all are dismissed.
All right.
Thank you, Your Honor.
Thank you, Judge.
You're welcome. All right, Elle and Jamal, I'll reconvene at 1 o'clock for my appeal.
Okay.
Yeah, so whatever questions you have about earlier, just save them, and then we'll talk about it at the 1 o'clock.
Okay, let me write them down because I'm old and I forget stuff.
Okay.
One.
What you say, Elle?
I said I will be back at 1 because I got some questions.
Yeah.
All right.
I will see y'all at 1 o'clock.